retaliation. Here we go. Gonna do a new playlist. We're gonna do the elements of retaliation just like we did the elements of sexual harassment. There's 3 elements to retaliation: protected activity, an adverse action, and a causal connection between the two. It sounds easy, but actually it's super duper complicated. We're gonna start with protected activity. So a couple caveats before we get started. This is protected activity as defined by Title VII, the federal anti-discrimination law that applies to employees and employers. Blake Lively has also sued under FEHA in California. I don't know if that law differs greatly on this issue. If it does, I'm sure Little Girl Attorney or somebody will tell us about that. But this is for the federal law. This is the stuff that I know. It's not going into any individual state law. The second caveat is that I know that there is a paragraph in the rider and the 17-point list that says you can't retaliate against Lively for having entered into this addendum to the agreement. I'm not going to, contractual retaliation provisions, that's a whole nother discussion. And we can't cover all that in 10 minutes. So I'm not going to be discussing that part. I can cover that in a separate video if you guys want to. So as a policy matter, why do we have retaliation laws at all? We have retaliation laws because laws are passed, federal laws are passed that give citizens and people in the United States certain rights. These are federal rights that you now have because Congress has passed a law saying you have these rights. And that helps to protect you. But that's not all of it. You also need to be protected for complaining about not getting the rights that you're entitled to. Otherwise, the rights don't mean as much. So while today we're going to be talking about retaliation for complaining about discrimination, there are retaliation provisions in lots of federal laws and some state laws too. For, if you engage in this certain protected acts, if you take advantage of a right that you have under the law and then somebody takes action against you as a result of you exercising your legally protected right, that can be its own claim. Like there's an FMLA retaliation provision. If you take Family Medical Leave Act and then you come back and they're like, yeah, you were out for too long having the baby, you're fucking fired. You can't do that because that's retaliating against you from doing something that the law allows you to do. So there's retaliation provisions all over the place. The one we're going to deal with here is Title VII and retaliation for engaging in protected activity, which is the protected activity of complaining about discrimination in the workplace. So generally, protected activity is exercising your right to speak out about or to oppose, or both, unlawful conduct in the workplace. You're either saying, this is happening to me and I want the employer to fix it, or you're saying, no, I will not do that because I don't have to, because the law says that I don't have to do that, or you can't require that of me. It can be oral or in writing. It does not have to be in writing. It helps, but it doesn't have to be. The law is very clear that internal complaints inside an employer can be enough for protected activity. You don't have to go to the EEOC to engage in protected activity. It can be an internal complaint as long as all of the other requirements are met. What you need to do when you're engaging in protected activity is you have to put the employer on notice that you are complaining about something that you believe at the time is against the law. It actually doesn't have to end up being against the law. Remember that both discrimination and retaliation can live without each other. But for it to be protected activity, you have to put the employer on notice that you are, what's the language? Because I had to write it down. I haven't looked at this case in so long. That you had a reasonable belief in good faith that the conduct you're complaining about is unlawful. Even if it turns out not to be unlawful, you believed at the time you brought it up that it could be. That's protected activity. Now, someone asked before, do you need intent? Because I'm always saying you don't need intent for sexual harassment. And you don't actually need intent for retaliation, but you do need knowledge, right? So Blake Lively doesn't have to prove that Justin Baldoni intended to retaliate against her. She does have to prove that she engaged in protected activity and that he was aware that she had done it. Because if he takes some adverse action against her and he had no idea she had complained, then he can't, by definition, retaliate against her for the complaint. So what's enough? This is where it gets very fact specific in the facts of each individual case and the conversations and the documents. It's very specific to each case. There is no bright line rule to say when you say these words, it's protected activity, and when you say these words, it's not. But overall, sort of an overarching concept, it has to be clear to the employer that the employee is complaining about more than just like general unhappiness at work. You have to be able to show that you told them enough for the employer to be like, I think this person's complaining about being in a protected category and that something is happening to them only because they're in that protected category. It can't just be, this place sucks. I mean, as I say to clients all the time, all work environments are hostile and all supervisors are harassing. The question is, are they doing it in violation of the laws? Are they hostile because someone's in a protected class? Are they harassing you because you're in a protected class? If you just work in a place where people are hostile and harassing and rude, that is not a violation of the law. Now, there are no magic words. You don't have to, as I've said before, come in and sit down in front of HR and say, my name is Blake Lively and I was sexually harassed last Tuesday. You don't have to do that, but you have to give enough information that the employer knows or suspects that what you're complaining about might be discrimination, right? So if you just say, I'm being discriminated against, but you don't say based on what category, that's not going to be enough. If you say, these people are out to get me, they hate me, which is the people I work with, they hate me, that's alone not going to be enough. If you just say, oh, they're always teasing me over there, they're just bothering me, or that guy walks by my desk way too often, that's not going to be enough. There's some case law out there that says if you just complain that you're unsafe without saying what you're unsafe from, that's not going to be enough. Now, a good HR department will follow up. So if somebody comes in and says, you know, I feel like I'm being picked on by my supervisor and, you know, for some reason I'm the only one that she picks on and it's really, really bothering me. A good HR person will then say like, well, tell me more about that. Why do you think you're being picked on? You know, and if somebody says I'm the only man in the department, then it's like, okay, that's putting us on notice that we might have a discrimination claim here. If they say, oh, you know, I think the reason she picks on me is because she's jealous because I'm married and she's not. That's not discrimination. So a good HR team will help you tease out when a general complaint or a whole bunch of concerns are just word vomited at HR. Are there things in there? They can be mixed and combined. It can be legitimate mixed with non-legitimate. A lot of times people will write like a tome of an email and you have to go in there and figure out like, no, ooh, that could be something, right? And then figure out where to go from there. But the employer does not have to create a claim for an employee. So if you have an employee come in and say, I'm just really uncomfortable and I just don't like Bob and he's just really whatever. And like, well, tell me about that. Yeah, he's just always walking by my desk and I don't know, he's just like grins at me funny and I find him kind of weird. The employer does not have to go, do you think that's because you're a woman? Do you feel sexually harassed? That's not their job and that's not their legal obligation. It's their obligation to ask enough questions to make sure that you understand whether the employer is being put on notice of potential discrimination. So how does this affect Lively? I'm going to have to go into part 2. Well, in her complaint, when she's talking about protected activity, she alleges that complaints were brought to Wayfair, but she doesn't say to who, and she doesn't say what about, and she doesn't tell us what they said. She includes messages between her and a third party, another person on set, she claims, arguing amongst themselves. And she claims the other person was also a woman, so we can draw the conclusion that they were complaining about women things. But we have yet to see what she actually told Wayfair. Did she put them on notice that she was complaining about potential sexual harassment and not just that the workplace sucked? So let's go to part 2 and I'll go through the 17-point document and explain it to you.